And a very good morning to all of our listeners out there. Of course, it's a Tuesday morning at 9 a.m. and it's the time of the week when the Law and You comes to you live from the 4CRB studio. Now, unfortunately, John Fradgley, who you're used to listening to, is still away on a hiatus. So this morning you have Daniel Bycroft, one of the associates in the dispute resolution section at Bell Legal Group. And I'm joined in the studio this morning by partner Tom Trembath. Good morning, Tom.
Good morning, Daniel.
So this morning we're going to change things up a little bit and speak about property law. So we're going to speak about all things to do with buying and selling houses, conveyancing, body corporate issues, residential tenancies issues, the things that should be in and should be out of a real estate contract. So if you do have any questions, or if anything pops up from the items we're speaking about that you'd like some more information on, of course the phone number here is 55 208 888. That's 55 208 888. And if you're into all things to do with the internet, you can, of course, write in your questions by email. Now, that email address is talkback@4crb.com. So I'm joined in the studio this morning by the property law partner from Bell Legal Group, Tom Trembath. Now, Tom, we see a lot of people coming unstuck with a contract of sale when they're buying and selling a house. Are there any little tips or hints you can give to people when they're entering into a contract of sale?
Yeah, Daniel, thanks. I guess the biggest things I see is from the outset is getting the original contract of sale done correctly from the start, and it's always my advice to come in and see a solicitor prior to execution of the contract, as once the contract has been executed by both the buyer and the seller, it's obviously a binding agreement, and from that point forward it cannot be changed unless it is agreed to by both parties. Therefore, that's why it's so important to get the contract right before it's fully executed.
And Tom, we often see it's almost become standard practice now, because there is a Real Estate Institute of Queensland standard contract, that we often see real estate agents that will just sort of fill out all the details for you, and it's their practice that they encourage the seller to sign the contract, so then they can use that contract as an offer to different buyers. Would you think that's a smart idea for people to sign the contract in that way, or should they have the whole thing checked out before signing anything?
Yeah, they should definitely have it all reviewed by a solicitor before they sign anything. Like you mentioned, it is a standard, what we call REIQ contract these days. However, there's obviously provisions for special conditions, subject to finance, subject to building and pest, and situations like that are something that need to be discussed with the solicitor. So either obviously the seller or the buyer, their best interests are protected.
And what are some of those relevant special conditions that you've seen people missing? For example, if someone is selling their property and looking to move into, for example, a retirement village or an aged living facility or an apartment, are there any special conditions in particular that you could encourage them to keep in there? Yeah,
for something like that, I mean, obviously if you're moving into or going to be potentially buying a new premises, the biggest thing you obviously need to be concerned about is having sufficient funds to complete that new purchase. And if it's a situation where you're borrowing from the bank, you'd have a subject to finance clause inserted. However, there is obviously certain situations where you wouldn't borrow from a bank, and you might be relying on funds from a sale to go through to give you adequate funds to complete a purchase. In that situation, it is obviously my strongest advice that you would see a solicitor, and I would insert what we call a subject to sale clause. And that condition would be something along the lines of the purchase contract is subject to the completion of the sale contract, and that would be the protection for the buyer, to mean that if their sale doesn't go through, then they can get out of their purchase contract, just to avoid any loss of deposit or any future loss incurred.
And one other thing that we do see as well is often people have worked hard their whole life and paid down their mortgage, so it can be the case where the mortgage is completely paid off, but unfortunately they've either forgotten or just missed taking that final step, which is actually having the mortgage removed from the title of their property. Do you see that happen often?
Yeah, I do see it a lot, Daniel. It sort of comes to halfway through the conveyancing process, I suppose, and I say to a seller, I say, you've got this mortgage on your property, and they say to me, no, I paid out my mortgage 10, 15 years ago, and I sort of send them what we call a title search, and it says mortgage to XYZ Bank, and they say, well, I've paid that off, and I say, that's fair enough, but it hasn't been removed from the title, so the buyer doesn't know that property's been paid out and is unencumbered, and it is still the process that we would need a release of that mortgage on the settlement date. So I guess for all the listeners out there, it is important if you think you've paid out your mortgage that you go into your bank and ensure that it actually has been removed from the title and your property is what we call unencumbered.
Yeah, so I guess the main take home from that is even if you've paid your mortgage down so there's nothing remaining on the loan, don't assume that the actual mortgage will be automatically removed from the title of your property. You need to take positive steps to go into the bank and have them remove that from the property. Otherwise, it could be a little issue that pops up down the track, and it might hold up a settlement or might hold up the sale of your property in the future. So for everyone listening, once again, our dial-in number today is 55208888. If you have any questions this morning regarding contracts of sale, property, body corporate issues, residential tenancies disputes, or anything along the lines of property law, it's a good opportunity for you to ring in while we have one of the Bell Legal Group property law partners in the studio this morning. So on to another issue, Tom. We see a lot of people that are buying and selling apartments that are in a body corporate. Are there any little special things that they need to keep in mind if they're buying and selling an apartment in that sort of setup?
Yes, specifically if you're selling within a body corporate, when a contract's drawn up, you need to attach a body corporate disclosure statement, it's called, and that statement discloses the body corporate levies to the buyer. And that statement is attached to the contract. If that statement isn't attached to the contract and signed by the seller before the buyer signs the contract, then under the Body Corporate and Community Management Act, the buyer can terminate the contract at any time up until the settlement date, which is obviously not ideal for the seller and obviously creates that uncertainty and that risk. Therefore, again, it's another example of obtaining legal advice before you enter into the contract and making sure that that disclosure statement is attached to the contract and does reflect the accurate body corporate levies.
And what other sort of details would be in that disclosure statement? What other information is disclosed to an incoming buyer?
Yeah, the body corporate disclosure has such information as who the body corporate manager is, like I mentioned, the admin fund levies, the sinking fund levies, any special levies which have been struck which a buyer should be aware of, because that could influence their decision in purchasing it, any insurance requirements, and it often has the sinking fund balance which a buyer should also peruse and be aware of.
Yeah. Okay. And then as we start moving through the sale process into what many people call the conveyancing or the searches period, what are the standard searches that you could recommend for a buyer of a property to undertake?
Yeah, the main ones is you want to undertake your council searches for your rates and your water levies. They're the first ones of concern. Those searches will show any levies outstanding, and that's important because if there are levies outstanding, your conveyancer will need to adjust on those on the settlement date, and obviously be a credit for the buyer, because if they're not adjusted, then the new buyer of the property will be responsible for those levies. A similar situation to that is also an adjustment for any land tax owing on the property, and the same with body corporate levies. Again, they will need to be adjusted if they are in debt. So they're the main searches. The other common searches we do are a contaminated land search for a house to make sure the site isn't affected, as well as often Queensland transport searches. And there's a whole extensive range of searches which are discussed with the client and applied to each relevant situation.
Yeah. So, and one other thing to add there is, coming from a litigation and dispute resolution background, it's imperative that you also conduct a court search, especially if you're buying a property that's on a body corporate sort of setup, because you have to keep in mind that often now these body corporates are involved in disputes, and if those disputes aren't resolved at an early stage, they can lead to formal court action. So if you're buying into a building that has a body corporate, and that body corporate is involved in litigation, there's a risk that down the track they may have a decision made against them, in which they may be liable to pay hundreds of thousands of dollars of damages. And if that does happen, then they're going to put out a notice to all the members of the body corporate or lot owners to contribute to those to those damages.
And just on that, Daniel, as well, if potential buyers are concerned of something like that, you can put in a further special condition prior to entering the contract that says that the contract's subject to body corporate inspection records, and if that's a concern, you should tell your conveyancer or your solicitor, and they can conduct what they call a body corporate inspection record search. And it's not a usual search, but if you have concerns regarding that, it's something we would advise, and that search will show you the body corporate minutes in particular, and you'll be able to peruse those and see if there is any disputes or any sort of serious works that are coming up and any costs involved with that.
Okay, Tom, so we've got a caller on the line now. We'll go to David. Good morning, David.
Hi.
How are you?
Yeah. Oh, good, thanks. I was just considering putting a second dwelling, like a granny flat, at the back of my property. I'm just wondering what's involved in doing that in New South Wales.
I think the first step, David, is to go and see a town planner. That's your number one step, and see the town planning requirements. There's a number of ways you can go about putting a second dwelling. You might want to subdivide the lot, or you might put the dwelling on the existing lot and not subdivide it at all. But I think your number one first step is to go and see your town planner, because each sort of area is going to have different rules and different regulations surrounding that. So that's your first step, and then I guess if it can be done, then you'd come and see your solicitor, and they're sort of responsible for all the titling side of things.
And I suppose the other thing, David, is that the town planner can also assist you with the various regulations regarding the structure of the building, how it can be built, how many levels, how high you can go, how close or how far away it needs to be from back boundaries. So we always advise clients that the first step is to go and see a town planner, and then when you need any legal work done regarding the title of the lot, we're more than happy to assist with that.
Right. So even when it comes to water, you'd have to decide the town
Yeah, sorry, David, you're just breaking up a bit there. We'll just put you back to the switch and we'll see if we can get that line tidied up. If you'd like to call back, you're welcome to do so. Otherwise, like always, we're more than happy to speak with people off the air after today's show if they need any specific advice. So we might go to a couple of messages from our sponsors now, and we'll be back shortly to speak about all things property.
Join the MV Lady Brisbane for a relaxing and memorable day of sheltered water cruising through the Broadwater, Sovereign Islands, Jumping Pin, Stradbroke Islands and Moreton Bay Marine Park. This is the only service operating on the coast. Call the fabulous booking crew at our sponsor, Brisbane Cruises, for the Captain's Special. Only $89 per adult for a 6.5-hour cruise with morning tea, delicious barbecue feast and afternoon tea on 3630 2666 or visit brisbanecruises.com.au.
Harvey Norman Tweed massive half-yearly clearance on now. 50 months interest-free. No deposit, no interest with 50 equal monthly payments until July 2023. Harvey Norman massive half-yearly clearance. Furniture, bedding and flooring. Home appliances, televisions and technology. Minimum finance demand $750. Approved applicants only. Interest applies if you do not comply with terms and conditions. Fees and exclusions apply. See website for details. 50 months interest-free. Store-wide. No deposit, no interest with 50 equal monthly payments until July 2023. Harvey Norman massive half-yearly clearance on now.
Our sponsor.
And a very good morning and welcome back to everyone. It's 9:22 on a Tuesday morning, and of course that's the time we all look forward to the law and you. Yours truly, Daniel Bycroft here, and I'm here with the property law partner from Bell Legal Group, Tom Trembath. And this morning we're talking about all things to do with property, Tom.
Thanks, Daniel.
So once again, that phone number 55208888. If anyone wants to ring in, if you have any curly questions about contracts of sale, body corporates, residential tenancies disputes, or anything property related. So we're going to have a little chat now about people that are looking to rent their property out. Now, often it's the case where people will buy a property out as an investment. And as part of that investment strategy, they'll have to rent the place out to a tenant. Now, we see this creating many issues, and all of the issues seem to stem from the original transaction when the property is rented out. Now, before we get too deep into that one, I can see we've got Robin on the line. So good morning, Robin. Good morning, Robin. Are you there?
Oh, yes. Good morning. Yes. Look, I've just got a question. What problems can arise in selling a unit with a body corporate if the garages do not have exclusive use on the CMS and they're freestanding on common property?
So, Robin, just to clarify your question, so the garages aren't exclusive use. They're sort of... So they're just, so they're not exclusive use, and allocated to a particular lot. They're sort of on more or less common property, and it's, anyone can sort of park in whatever garage they want. Is that your question?
That's right. They're just assumed that they're connected to the, unit, behind them.
Yep. So, Robin, my advice for that is, and I do see that it's not common these days, but it does often pop up with older unit blocks, and I mean to the letter of the law that means obviously that no particular lot has an exclusive use to a particular car park. So when you're selling, you should instruct your real estate agent to say to any potential buyers that these garages are just on common property, and this has been the one allocated to your particular unit over so many years. However, we cannot guarantee that. You're entitled to exclusive and free use of this garage. So I think the number one point is just to be clear with any buyers, because if for whatever reason you disclosed that garage as an exclusive use garage, there would be the opportunity for a buyer to terminate that contract up until the settlement date.
Okay. Now, if you try and get exclusive use put into a new CMS, you have to have 100% in agreement. Now, if some parties, a party or some parties, are refusing to proceed with this, what are your alternatives in which to actually have this included in a new CMS.
Yeah, you're 100% right, Robin. To have any exclusive use areas, you need 100% consent of all lot owners. The next step, if you can't do that, unfortunately, is the expensive process of potentially taking the matter forward to court and getting an order of the court. Which is obviously expensive. I mean, the first step I would advise before doing something like that, because obviously court action is the last thing probably everybody wants to do in terms of cost, is maybe the majority of the body corporate could write to this one lot owner or two lot owners or whoever they are sort of holding out on the decision, and maybe put a bit of pressure on them to obviously make everything exclusive use. And I'd also be wanting to point out the benefit to those to those other lot owners as well, because to me it's going to increase the value of the property if each person has their individual exclusive use areas.
Yeah, thank you very much for your question, Robin. Unfortunately, we're starting to run a little bit short on time, so
that's fine.
You're welcome to leave your number at the switch, and Tom can speak to you later regarding those specific questions you'd like. So we'll go now to Frederick. Good morning, Frederick.
Yeah, one question. Can you hold back some money after settlement for small items which were not really shown up in the final inspection? Let's say sometimes they hand out the keys and they don't fit really the locks. There might be certain items with the, laundry or what, things which I was caught with somehow stuff of about a value of $300 which did not work. But settlement was done, and when I moved in, they said, "Oh, this is annoying. This is so kind of hidden little items. Can you hold back some money to find out hidden sort of tiny small folds?"
Yeah, thanks for the question, Frederick. The answer to that is you can request that to the other party and sort of say, look, I'm not prepared to settle because of these items, and I want to hold back X amount of dollars. Otherwise, I'm not going to complete settlement. There's no reason you can't do that. However, if I was your solicitor, I would say, look, we can request this, Frederick. However, if they say no, then you are not in a position to hold up or refuse settlement. So the answer is, yeah, you should definitely request it, and there's no reason you can't request it, but you would not be able to not complete the settlement of the property on that basis, as it's not big enough to end a contract.
Yeah, and I guess, Frederick, just following on from that, the other thing is once settlement has been effected, so we're talking about after settlement now. If you have accepted the property in the condition it's in, including the keys, including the garage remote controls and everything else, you no longer have a legal right to hold up, or to request any further money under the contract, because the contract is settled. It's said and done. And that's why we always encourage our clients on the day of settlement, or even the day before, to go and complete what's known as a pre-settlement inspection, where you go to the property, you make sure all the keys work, you make sure there's no one still living there, you make sure that nothing has been left behind, for example, big rubbish in the backyard or car bodies, things like that, because you want to get on top of all those things before settlement is effected.
Yeah, but sometimes a bit difficult, particularly when tenants were living there before, and even with this inspection then before settlement, that little items here which creeping up then, and you said, oh gosh, this was not shown up, and only when you really use the stuff, and then you said, oh God.
Yes, we can understand your pain, and we see that all the time. But if you'd like to go back to the switch there, Frederick, and you can leave your number, and I'm sure Tom or someone else from our office would be happy to give you a call today and have a bit of a chat about those items. But unfortunately, as usual, time goes really quick on the Law and You. So we've already hit the 9:30 a.m. mark, and that means it's time for us to wrap things up on this Tuesday morning. So thank you very much, Tom, for coming in.
Thanks for having me, Daniel, and thanks for having me, the Law and You.
And I'm sure if our listeners out there would like another Tuesday morning Law and You edition on property and property issues, feel free to send in an email to talkback@4crb.com or give the radio station a call, and Tom and I would be happy to come back in and have another chat. So this is Daniel Bycroft signing off, and a very good morning.